Distinguished ladies and gentlemen, we welcome you to this press conference organized to address certain critical issues affecting our nation. The Lawyers in Defense of Justice and the Rule of Law is a forum of distinguished members of the legal profession committed to addressing critical matters that impact our national polity. Today, we wish to comment on issues surrounding the proclamation of state of emergency in Rivers State. After careful and detailed analysis of the situation, we make the following statement. In doing so, we have elected to provide both legal context and factual insight regarding the concept of state of emergency under the Constitution of the Federal Republic of Nigeria 1999 as amended, the circumstances prevailing in Rivers State, and our conclusions therefrom. A state of emergency is a governmental declaration that may suspend some normal functions of executive or legislative branches, alert citizens to alter their normal behavior, or mandate government agencies to implement emergency preparedness measures. Such declarations usually arise in response to natural or man-made disasters, periods of civil unrest, war, or imminent breakdown of law and order. From the above, it is evident that the suspension of fundamental rights guaranteed under the Constitution as well as democratic institutions is both implicit and inherent in a state of emergency. The power to declare a state of emergency is clearly provided under Section 305 of the Constitution of the Federal Republic of Nigeria. For ease of reference, Section 305 sub 3 provides that the President shall have power to issue a proclamation of a state of emergency when there is actual breakdown of public order and public safety in the Federation or any part thereof, to such extent as to require extraordinary measures to restore peace and security. There is clear and present danger of an actual breakdown of public order and public safety in the Federation or any part thereof, requiring extraordinary measures to avert such danger. It is public knowledge that Rivers State has witnessed significant political unrest since the beginning of the conflict between the executive and the legislature. For over 16 months prior to the proclamation, the state had been in a highly tense atmosphere. Numerous legal contests were filed in various courts, yet even while the matters were pending before the judiciary, some parties resorted to self-help, thereby escalating tensions with threats to lives, public safety, and national assets. For the avoidance of doubt, the executive arm, led by Governor Fubara, lost all related cases at the Supreme Court. One would have expected that repeated pronouncement by various courts addressing the governor's executive excesses would have restrained him. However, it became apparent that the governor was determined to undermine democratic institutions and elevate tension in the public space, thereby endangering lives and property. In an address to Rivers State youths during the commissioning of a project shortly after the Supreme Court verdict, Governor Fubara made inciting and inflammatory statements. Whether by inadvertence or design, one such statement involved a call to youth to stand by and await instructions at the appropriate time. The implications of such an unguarded and open-ended charge were dangerously clear. It had the potential to embolden overzealous followers and to act unlawfully. Indeed, shortly after, youth groups began issuing threats to national assets and security. The governor, whether overwhelmed or misadvised, failed to promptly dissuade them or de-escalate the situation. In rapid succession, national assets were targeted and destroyed. The situation presented a clear, present, and imminent danger of a complete breakdown of public order and safety. The governor had the opportunity, pursuant to Section 305 sub 4 of the Constitution, to formally request a state of emergency. Doing so would have demonstrated good faith and dispelled any suspicion of complicity in the destruction of national property. Consequently, the President and Commander-in-Chief was left with only one viable course of action: to proclaim a state of emergency in Rivers State to restore order, protect national assets, and preserve the integrity of the country. It is important to reiterate the destruction of national assets, especially those constituting the nation's economic base, is a matter of national security. In any sovereign state, national security supersedes any individual rights or interest, including fundamental rights. Subsections 1 and 2 of Section 305 of the Constitution lay out the procedure for declaring state of emergency. The President shall issue a gazetted proclamation. He shall transmit the proclamation to the National Assembly, the Senate, and the House of Representatives. In the case of Rivers State, the President fulfilled both requirements, and the National Assembly duly endorsed the proclamation. Subsection 6 further provides conditions under which the state of emergency may be terminated, most notably if the National Assembly fails to approve the proclamation, there has been no breach of constitutional procedure in this instance. Suspension is inherent in the concept of a state of emergency. The entire purpose of such a proclamation is to suspend normalcy and constitutional procedures, allowing for extraordinary measures necessary to contain the threat and restore order. We therefore fault the protest by our colleagues who protested at the U.S. Embassy. We note that such protest was embarked upon without due consideration of the facts and law relating to the declaration of state of emergency in Rivers State. Historically, in all declarations of a state of emergency in Nigeria, government functionaries, including governors, deputy governors, and state assembly members, were suspended from office. Administrators were then appointed to govern during the period of emergency. Examples include that in 1962, Dr. Majikodomi was appointed administrator of Western Nigeria. During President Obasanjo's era, General Chris Ali was appointed the sole administrator of Plateau State, while Tunji Olurun was appointed the sole administrator of Ekiti State. We state categorically that the suspension of Governor Fubara does not amount to removal. Suspension is a temporary administrative action. Removal of a governor is a separate process governed by Section 188 of the Constitution. In this case, the governor was not removed from office, but merely suspended pending the resolution of threats to public safety. Once peace is restored, the governor resumes his duties. We note as follows that the conditions for the declaration of state of emergency existed in Rivers State. The procedure for such proclamation was duly followed. The proclamation was adopted by the National Assembly. We find no evidence of breach of the Constitution in this regard. In conclusion, we affirm that Mr. President acted in full compliance with the Constitution, and we commend him for prioritizing national security and public safety. Thank you so much for your time.